Welcome to this second webinar in this series we call From Crisis to Action. Thank you very much for joining us. My name is Andrea and I will be moderating this discussion. With me, I also have my Crisis to Action colleagues Malin and Linnea, who are handling all the technical stuff. We are moving over to our two speakers, Georg Stawa and Niklas Söderberg. We are very happy to have you here and that you are taking the time to participate. George, just very shortly, you currently work as the judicial attaché at the Austrian Embassy in Belgrade. And you, Niklas, you work at one of the best places in Sweden, which surprisingly is where I work too. So I'm going to let you two introduce yourself. Would you like to start, Georg?
Thanks a lot, Andrea, and very warm welcome and good morning to everybody. Introducing me briefly is talking about that I started my career as a judge in Austria, mainly for civil cases in first and then later second instance. And then I switched to the Ministry of Justice, court management, classical style, human resources first and then strategic development. Later on became also General Secretary of the Deputy Prime Minister for some time, and in parallel I was always quite connected with the European exchange level of the Council of Europe, namely the Commission for Efficiency of Justice, some kind of think tank of the Council of Europe dealing with questions on how to improve the efficiency of courts, how to measure this while keeping the sensitive issue of independence of judges, and was then also president of this kind of commission and very much connected with this community still. Last year I switched down to Belgrade, to the Western Balkans as a judicial attaché for the government, and working here a lot on justice reform, exchange, and being the link between classical link on as an embassy does between the government at home and the local professionals here. So this is it in brief.
Thank you very much, Georg. And Niklas, who are you?
I'm, as you said, working at the same place as you are, Helsingborgs Tingsrätt, District Court of Helsingborg. I'm a senior judge there. Apart from that, these days I'm involved in some ADR. I'm frequently used as a mediator, and I'm on the arbitration board of the Chamber of Commerce of Southern Sweden. Before this, I've done my fair share of court administration. I've worked at the Ministry of Justice, drafting laws regarding courts and judges. I worked at the Central Court Administration with the distribution of funds between courts, and for 5 years I was the administrative director of the Court of Appeal in southern Sweden. So that's me in short.
Thank you. So the main purpose of this webinar is to highlight the impact of COVID-19 on courts and people's access to justice, and to discuss the future role for courts in our society. We will now dive into the first question. So the pandemic has caused dramatic changes in people's lives during the past months. It has also changed the daily work and routines of court. In some countries, the courts have almost completely shut down. The number of trials and hearings have been heavily reduced. In the United States, courts in many states have started using remote hearings for most kinds of cases, using video conferencing platforms. From your perspective, in what ways has the pandemic affected the courts?
I may like to start with some kind of general headline, because I think this is very much important. We are talking about a health crisis. It is not to talk about the crisis of rule of law or a crisis of the institutions themselves because they are not able to work or whatever. The rule of law is not on sick leave. Yeah, so whatever we done before, I think we should try to keep as much as possible. It is not the law which is affected. It is not the courts themselves as an institution affected. It is just the circumstances by the health crisis. This is very much important because the crisis also offers a lot of opportunity we'll talk later about, which is maybe a positive opportunity to change some of our habits, but it's also an entry door for a bad influence, let's call it like this, by whoever wants to change the rules and the systems. And as we judges are, of course, selected and trained to be very conservative, which usually is our disadvantage a little bit, in that kind of context, we should use it as an advantage. We should keep that super tanker of judiciary I always say this justice system is a super tanker and not a speedboat. So we are famous for keeping the track for the next 10 miles, definitely. We should keep that habit. And then, of course, we should have the focus on the fact that we are firsthand providing our services. We will talk about services later, as much as possible as it is to continue. Of course, this is not possible for some technical means, so we will have to look for workarounds. We will have to think of how to adapt. But the main topic is, let's do our business. Let's follow our mission. Of course, the, let's say, technical circumstances are affecting our business, and we'll come back to this later. But again, also let's see this from two perspectives. Let's see that this is also an opportunity to come up with technical solutions which we already have in the tube. It is not that we have to develop everything. I think it is a good opportunity to make use of some kind of video conferencing tools, for example, in easy cases, in easy trials where this is no problem, with two lawyers and maybe an expert as professionals are sitting together. Let's speed up some things. Let's maybe talk about what to be outsourced. Maybe we find some solutions even to do more online dispute resolution on internet completely without the judiciary or with just their technical system. There's a lot of opportunities. But on the other hand, let's have a very clear perspective on what we will not accept. Let's have a clear vision of not leaving our mission. And let's have a clear focus on that if the crisis ends, also we can be able to step back to those things we really appreciate. Because that is also something we have to keep in our back mind, so to say, that the crisis may not end intentionally. So this is from political point of view, it's very tempting also to say, okay, we still have a crisis. The second, the third, the fourth wave will come. We cannot go back to what we consider normal for whatever reasons. And at the moment, we are very much focused on governmental issues, but this is not only the government. So it may be the bar, it may be some, I don't know, other associations, or even just the normal public who thinks it is not necessary to do it complicated like we do. There must be other solutions, etc., etc. So main message, it's a health crisis. Let's go on the track, and then let's sort out these technical things we are now dealing with. I think we talk about this in the next round. Maybe Niklas wants to comment this a little bit.
No, I agree to everything you say. Of course, different countries have taken a different approach to the corona situation, various degrees of lockdown, etc. But I guess we all could agree that irrespective of which approach you take, the courts are not the worst place to be. We are not at a very high risk compared to medical services, police officers, etc. And the society has an absolute requirement that the police still works, the police still functions. The medical service must keep on functioning. And of course, the courts must keep on functioning. It's not an option to, in my view, to close down the court services. Both George and I took part in another international webinar a couple of weeks ago, and then we heard from other jurisdictions, and it was interesting to see and to hear the different degrees of how much the courts had closed down. In Sweden, as you all know, the Swedish approach has been no lockdown, the business as usual to an extent as far as possible, and that has been the approach of the Swedish courts as well, most of them. So we have heard cases pretty much as normal, and we've been delivering justice pretty much as normal, which has been good. Not for us, but for the public.
And to avoid any risks in the future with limited access to justice, how do you think courts could prepare for the future to make sure that people will still have access to justice if we should get another one of these health crises? Because some countries have been, to a greater extent or to a less extent, prepared for this. The less digital you are in your working methods, the more difficult it has been to handle this health crisis and keep the wheels turning. Are there any specific things you think that courts could do to prepare for the future?
I think what Niklas said is if you decide to shut down the court's activity, it is clear that you cannot stop providing judicial services at all. You have shutting down the court in all the countries means that at least there is a track open for very urgent cases, meaning also everything which is criminal and people are detained. So you have to follow the rules and of course and hearings and court decisions on this. And of course, you have civil cases which also are very urgent, mainly in family law, which is not able to postpone. So you have to deliver the service anyway. The solutions I saw then is a mix of either you do this physically as nothing has happened and protect with keep the distance and disinfect everybody more or less, or you switch it to online services, but this is also a very limited thing because first of all, the majority of countries do not have some kind of consolidated running system. If you came up with some ad hoc solutions like let's have Skype meetings and do hearings on Skype where at least one of the party is sitting somewhere in front of a screen and the others are gathering in the courtroom, so there is mixed solutions as well. And the good news is that the solutions which were pulled up ad hoc, it seemed they worked. They were sometimes criticized because they are new and the bar was not always in favor of. But it seemed that stories I heard is that if you keep it in a smaller company and focus it on professionals, then it is possible, like in the real courtroom. Yeah. So if you have the classic civil procedure, which is an opening session, and you have a judge, and you have two professional lawyers sitting, and maybe you have one witness or you have one expert, and you're talking about technical things, then I guess this is the moment to say, okay, please, let's do this on the screen. There's really no difference if we have a connection like we have today. We could talk about professionally as well without any kind of disruptance of our the quality of service. If it comes on getting parties and let's say ordinary people involved, it is a mix of feelings. On one hand, we are always demanded that we should switch to modern times and we should offer more of fancy solutions. On the other hand, I may remind us that on average, people are in contact with the courts once in a lifetime. And a lot of our, let's say, impact or our business or judging is also a little bit having a show in a positive way. Yeah? Setting something up on stage in front of the public and having a court judge sitting there with those who are functioning in this trial and making it visible that there is something happen and what are the rules to follow is of course very precious for the public impact, not only for that person who is maybe once in a life in front of the court, but for the public in general. This is a little bit the tricky part because of course, if we ask for how can we prepare, then we can say, okay, we can shift into internet as much as possible. The medium thing is like, at least you can see on online screen who is acting. This is something people are quite used to, but still it makes a difference. I mean, if I'm sitting at home and feeling convenient, it is not the same like I show up in front of a courthouse. I have to go there, I have to appear there. I'm seeing other people and I understand better what is a witness doing if I appear as a witness. So this is a little bit the unsolved part.
We have quite an interesting question here from one of the attendants that I thought I might just throw in here. Oliver here asks us, what about the authenticity of testimonies? Are they the same whether they are online or not?
Yeah, this is a very good question. Thanks, Oliver, because I talked with an Italian colleague. In Italy, they still have the old-fashioned style that they present you a Bible, and we know it's a majority Roman Catholic country, so they give the swearing on the Bible if you are showing up as a witness. I don't buy this anymore. I mean, in the year 2020, the people, whatever they say in front of the court, you can impress them by telling them that they may end up in prison if they testimony in the wrong way. This is maybe impressive, but if you come up with all this stuff from the 18th century of speaking them formulas and letting them swear on whatever religion. I don't think so. Yeah, this is a method which worked 1,000 years ago, where this was some kind of a technical thing and worked like that. But I'm not believing it is really having that huge impact on 2020. There is maybe other options to nudge people to behave, let's say, productively. Yeah, so everything which has to do with money and
getting the testimonies online, that we do today already, don't we, Niklas? Quite often.
Yeah, of course we do. We use video conference systems. We've been working with video conference systems since 2008, fairly widely in Sweden. But of course, the use has been has exploded during the Corona. I read somewhere that the number of video conference calls from Swedish courtrooms are now about 3,000 per week, which is 150% more than normally. And the authenticity of witnesses, in reality, it's not a problem. I think at least it's not a big problem, because most of our witnesses, it's not the question whether or not they're telling the truth. We heard in the international webinar that I just mentioned that some jurisdictions thought it was an extremely big problem that you couldn't check the identity of the people in front of you, and some Eastern jurisdictions from Eastern Europe thought that was a large problem. And for a Swedish judge, it's not a problem at all, because I've never checked the identity of a people or of a person showing up at court. So why should I do it?
Sweden would never lie about that.
Yeah.
No,
but it is it's an important point, and it's a fun fact, but it's very important. As an Austrian judge, I also was never having any kind of guy who is showing up and pretending he is someone else. I cannot remember that ever this was an issue. Yeah. So I always have this rule that 95% of the people, if they show up in front of a court, like sitting us here, behave normally. Yeah. So they are mindful normally, they understand what's going on. And then you have 5 or maybe 2%, let's call them idiots, yeah, who either do not understand or do not want to understand or are obstructive. Then you have to manage them actively. But even then, I never had any kind of story I heard about that someone is pretending being another person. And if you want, then okay, then you can even present. You can ask them now, present me please your driving license online. Yeah, something they are not able to prepare in advance, or a second or whatever, bank card or whatever. I think this would even easily work on the screen. And even if you still think that, no, we have to, lawmakers, I'm sorry, I was also working in the ministry, but lawmakers always pretend that you have to make this 1% of exclusive idiots making the rule of the other 99%. Yeah, so if you really want to make this waterproof, then take a company on board who is specialized on proving your identity online. I was able to open a bank account online with just presenting all my identities online on the screen, and this worked. Yeah, so the guy was checking even my passport and doing pictures, etc. Took 5 minutes. So if you want to have this kind of standard, no problem. You can do this in online world. So why not in front of the court online? Not a big drama.
Very good. I think we are getting a lot of questions now about this. I think we will save them for later and see which ones to pick. Because
let me shortly answer one, because someone asked how about the ability to tell whether or not the witnesses are lying or not. I don't think that's easier to do when you have them 10 feet in front of you. Of course, we have 1 or 2 witnesses where the risk of them lying is apparent, because they are related to the guy who is charged with the crime, etc. It's the accused person's wife. The risk that she will lie to help him off, it's evident. It's apparent, and it doesn't matter if we hear her in court or online. Of course, she might be a bit more intimidated if we have her in the room. I mean, she might realize the importance of her testimony, etc. But as Georg says, 95% of the witnesses, it's not the question whether or not they're doing their best. They are doing their best to tell the truth.
Yeah. First of all, judges are trained to identify if it is the truth or not by de facto the experience. So it is not that someone intentionally wants to tell the untruth, but it is just that people really receive the real truth in different ways. Yeah? You must, everybody does it. So even the question, was it left or right? People mix up. People have a different reception. So, but this is something you're used to as a judge, and from the total story you have almost every time a really clear picture of what really then happened at the end, and you sort out those who are not matching with the reality. And on the other hand, that case Niklas mentioned with the wife, if the wife is the only witness in a sensitive crime, then exactly this is a court hearing we would then do likely in reality. Because not because of the wife is not willing to cooperate, but I would like to prevent that someone is standing in front of her and I can't see with the loaded gun and forcing her. So if you have only one source of truth and you know this is a sensitive issue, then of course you would prefer to have this in a physical room with protection measures.
Yep.
All right. So I'm ending this question here and head over to leaving the pandemic for a while and think about how it normally is in courts. How do you think today's courts are perceived by the public?
You want to go first, George?
If you want to start, you can.
I can start. I think as regards to Sweden, I think the classical questions regarding independence, etc., it's not a problem. I think the general public has a view of our court service being independent and delivering good judgments, etc. I think the problem is probably more that the people actually coming in contact with us, as George said, once in their lifetime. I think they probably think that it takes too much time and it's too costly, especially when it comes to civil cases, let's say commercial cases. The problem, in my view, and I think that is the problem that the parties see, that it costs way too much and it's too complicated.
I totally share this point. This is one of the disadvantages of our business, that even in let's say high developed countries with a high developed judicial system, let's take Sweden and Austria as an example, with a lot of online input and with a high quality level of delivering justice, we have really this problem that people are used that everything is going quicker. And if we compare what people understood what is quick 10 years ago, they understood that, I'm writing maybe even a postal letter and get an answer within a week was extremely quick. Nowadays, if you're not answering an email within 6 hours, you're too slow. Yeah? And even if we improved also the disposition time of our court decisions dramatically over the last 10 and 20 years, but still, if you tell someone, if you have a dispute, you get a court decision earliest in 3 months. And on average in 4.5 months in first instance, people look at you and say, okay, well, what should I do with it in 5 months? Yeah, this is like a parallel universe. So I think that there is a huge danger that we miss that point, and the gap is opening, that people are not going to court anymore because either it takes them de facto too long. If you're a businessman, you will maybe not wait 6 months to get a decision. And second is they do not understand anymore. Yeah, this is the next thing. We provide them something where they at the end say, okay, I mean, why and what, and it is getting complicated. It is not that we got more complicated than we did it ever before. It is just that everything else is demanding to get easier, more comprehensive, understood within 250 letter signs in a tweet or with 1 page on a screen. This is not the way we are set up to deliver our decisions. But as trust into judiciary is one of the major points, and also someone else will do the business if we do not deliver it. This is not seen in statistics. Yeah, stop a moment here. People who are not showing up in front of courts because they do not understand, it's too costly, it's too lengthy, they end up somewhere else, and somewhere else this problem will be solved either by the longest gun or the biggest money or whatever. And this is definitely not judiciary. So I invite all the political systems to, especially in Europe, to think of what is the modern way of delivering justice in, let's say, at least easy cases, yeah, which are not with that big amount of money in, where you say, okay, yeah, now let's go in front of the courts with 5 lawyers on each side. But delivering justice for, let's say, ordinary people on average cases up to, let's say, 10,000 euros, what is the way to deliver justice more or less immediately? And there's a lot of interesting things like online dispute resolution. One fact everybody also not sees in the official statistics, for example, eBay, which has a online dispute resolution system between those two parties trying to do a deal, solves 60 million cases a year. I don't know by heart how many cases Sweden is providing, but this is, I think, 20 times the Austrian judiciary. So if you would put them on a map, they would be the biggest judiciary in Europe. And this is where the disputes are resolved nowadays. Of course, easy ones, yeah. But let's a little bit jump into this business.
Yeah. And I just would like to add that I think the most important, the most common way of resoluting or getting out of now I lost the word. No, twist.
Mm-hmm. Yeah.
Dispute. Thank you. Is by not doing anything at all. Because you're unhappy about the situation, but you realize that going to trial, no. Going to taking it to arbitration, no. Can I do anything? No. So I just clench my fist and stay unhappy, and that is probably the most common way of solving disputes, and that just can't be, because then the biggest power is to basically sit on the money. If you have two parties that you mustn't be the one who wants a change, and that is a failure. And as George says, we usually tend to emphasize the small claims, but in my opinion, the large cases are also mishandled today, because 10 years ago, 15 years ago at least, it was normally you had a lawyer on each side, and if it was very complicated, one side might show up with 2 lawyers. Now, in commercial cases, the case doesn't have to be very big before you have 2 lawyers, and if it's relatively complicated, they have at least 3, and it's crazy. It's crazy, and they just produce all these texts that and who is happy? The parties sure can't be, because they pay for the show, but they are in those trials so seldom that they are not very good.
They're never to end up there again.
They don't buy judicial services very good. So I think that's a failure for the whole judicial system, that the cases are becoming too big.
So do the courts have to think about alternative ways of dispute resolution that aren't arbitration, obviously, but different ways, different procedures to handle cases more swiftly, cheaply than we actually can right now, because we don't have the technical possibilities and we don't have the rules that govern such a procedure.
Definitely. Let me give one example. We still do judiciary like in the 19th century. Yeah, let's go back 150 years when these geniuses in Europe wrote that procedural law books we are still following. They had in mind that 2 people stand up in the morning, saddle their horse, ride to the court with a claim in their hand, then they meet in front of the judge. In best case, the judge was hearing and deciding the case in a 1-day session. Decision was given. The guys were riding home again, one more happy than the other, and that's it. So, and if you look even on systems who are delivering justice with online services, the majority of them is still doing the same. We are writing to the court just by PDF, by scanned PDF. And now I ask you, in the year 2020, what is a scanned PDF? I mean, this is not data processing. It is just that showing me a picture of a document. This does nothing. It is just traveling a little bit faster to the court instead of sending it by physical mail. But otherwise, it is almost not offering anything better than. So we're still in this world where people are telling their lawyers a story. The lawyer is writing it down on a document, and it is scanned and it's transported in an electronic system, and the judge is reading it. This is one option if it really needs this, but we are all our law and all our structure we have is not set ready to get data in and processing this kind of data and maybe coming up in easy cases with more or less automated decisions where a judge is maybe rechecking it or is just checking those cases the system is not able to cope. But we are completely not thinking in this data streaming logic, because we as lawyers are also not trained. Yeah, this is total logic. None of the judges is trained for this, and this is not our way of thinking. But the lawmakers are also not. Politicians are also not. I would like to have that in all the countries where a lawmaker is drafting a law, a software engineer is sitting next to him, and if the drafter, the law drafter, is putting a rule on paper, the software engineer has to say, this is not able to put in an algorithm. You should reformulate it. If you read even modern law, sometimes you would like to shout out loud because it is clear that no one else ever can put it in an algorithm. But that means you need a human being interpreting it, investing time. And then we are at that problem that we need then minimum 3.5 months to decide about something. Yeah? It is not because the judge is not able to decide today, but it is just by a procedural law, and you need an expert and you need this and that. It is not able to do it quicker. And this is the point where we should not miss it.
No, and I think as up until now, the Swedish digitalization projects in the court administration system has involved how do we digitalize the current procedure. We are discussing things like how could you file the first paper without a signature in ink, or how do we archive our PDFs electronically instead of in a pile of paper. And that might be interesting to some, but it's definitely not interesting for the parties in a dispute. They don't care. It's not a problem for that they have to send their first paper in a paper, and they can send everything else by email, or they don't care how we archive their case. Nobody will look at it. They want a fast answer. And the problem is that we are stuck in our own, or in our old way of doing things, as George said, with the two men on the horses. And even if we use, for example, video conference systems, we use it in the same way. Once we have all the paperwork in, we say that let's meet in, if we are fast, 6 weeks via video conference. It ought to go a lot faster. But then we will have to address that some of our core principles that we have held as very important, such as the possibility for the public to visit our every court session that we have, that is probably going to be difficult if we
it's easier. I contradict. It's easier.
Okay.
No, maybe just by chance, not every, but publish a list of 100 or 200 court hearings by randomly each week you can attend online. I never understood why this is not done. If I go to a courthouse in Europe now, I can go in wherever there is a hearing, as long as it's not special cases and locked up, but I can listen and hear this. And this kind of, let's say, closed public or semi-open public, because you can put in 100 people, is the logic we're running it. But I never understood why, if a hearing is online like this, it could be open to completely to the public. Everybody who is bored enough to watch the proceedings and the trials about the car accident can follow this. And even this would increase the opportunity that it would enable much more to maybe raising the trust, showing what is really happening in front of courts. It would be like the permanent courtroom drama, but the real story. Yeah, so nothing to hide in a court trial, nothing to hide in a courtroom. They think modern technology would enable this to show more publicity and to show the people what is really going on. This is what we are criticized for. Nobody, and I understand, nobody knows what is going on in front of the court. People are always very astonished about. Yeah, people think it is all a criminal courtroom drama, which they know from American TV shows. No, it's not. Yeah, more than 90% is civil cases.
Thank you. I know in Sweden, at least, there is a prohibition against filming from trials, and that's the usual argument why we can't, for example, stream court proceedings. But just a last remark during this question, because I would like to move on, is that we open courtrooms in Sweden means physically open courtrooms, but I'm not so sure today that the public perceives courtrooms as very open or court proceedings as very open, because it's actually digitally closed. So that's something that also should be discussed, and the benefits and the disadvantages with doing, like you said, George, to be able to watch a proceeding from home, for example. So the next topic is modern courts, because in this book, Online Courts and Future of Justice, released in November 2019 by Richard Susskind, he asks the questions: is the court a service or a place? What do you think about this question, and what would your answer be? Are there different kinds of cases where it's easier to think of the court as a service instead of a place?
Short answer, I think it is quite easy to distinguish. First of all, there is some kind of court services, they even named like this in English. If you think about, I need a copy of a land register, I need access to a file, something like that. This is typical service, yeah. And in that kind of things, courts should behave like providing a service, and then it should be in the quickest, best possible manner, and not a lengthy bureaucratic story. If it comes on court decisions, yes, on a lot of cases we are delivering a decision, and you can of course consider this decision also some kind of service to the public, which it is. But if we talk about complicated court decisions and the court decision itself, it is more than just a service. And it is a creative act. It can become very complex. It is, I would say, not only a service, but it always has some kind of elements of service. And it starts with easy things like be on time, be polite, have a time schedule, tell them what it is. So you find a lot of elements which are from service industry and for good reasons should be followed. But there's also elements that we say is not a service institution on its own, and it's not as well.
I think as far as we talk about commercial cases, I have no bigger problem calling it a service, because the parties choose to come to us. They can choose to go elsewhere if we don't provide the service that they want, and they decide how to frame their case. So the word service doesn't sound too bad to me. When it comes to criminal cases or family law cases, it's something more than a service, probably a function or whatever you want to call it, but it's definitely not a place, because the courthouse has its advantages, as George pointed out earlier, that we put on a show, but I'm sure it could be made elsewhere just as good.
So a court is can be a service, but it can, in criminal cases, for example, you think it's a better description would be that the court is a function or has a function.
Yep.
Yeah.
Yeah, it has a social function. This is we never have to forget about that. The prime function of a court system is a social function. We deliver a product which is solving a social conflict in all of our decisions in the majority, and this is firsthand a social function still. Yeah, even on first instance, you are, I think, 30% a social institution of even people who are maybe wrong in front of the court, but they are looking for some kind of solution, some help. if it fits, the court system is even able to provide a solution, but in many cases it's just a mix of caretaking and listening to a story and providing them somewhere else where they are helped out more. So it is not only clear then in a crystal clear business case where two lawyers are coming up with a case. It's total other story. But I think in minimum 30% of the cases, the judiciary is providing a social function needed in the society to sort some things out.
Yep.
And no one else can do it. Or maybe they can in civil disputes, but some of us would like to keep the disputes, I think, in the courts. Next question, if you could draw attention to a certain question relating to the future of courts, what would that be? And what initiatives would you like to see after or even during the pandemic? Niklas, would you like to start?
Yeah, as I stated earlier, I think we need to stay relevant. We need to stay we need to stay relevant. And I don't see any big problems in the criminal cases or in the family law cases, but in the commercial cases, it's I'm not sure that we deliver. And it's not just us, it's the trial lawyers as well, that we deliver what the parties want. And Georg has addressed it, saying that it just can't take this much time, it just can't be this costly. And to solve that, I think we need to in a sense, think outside the box. For many years, mediation has been regarded as the savior. It's going to solve everything, and clearly it's not. People don't mediate their cases before going to trial, at least not in Sweden. The question has to be put there: how do we limit and contain the disputes so that they don't, as they do today, just bubble up and get too big? Because usually I think the parties go to the lawyers with a small dispute, and the lawyers realize, at least one of the lawyers realized, that he can't do anything with his guy's story because he's wrong. But then he finds out some other things that he could make a case out of, and then just goes on, and it becomes bigger and bigger and bigger. And I'm fairly sure that the parties themselves don't think that once they sit there on the final hearing and hear all the evidence, it's not what their original dispute was about. But then we have to start discussing how do we contain the disputes. And I think costs is a large question.
And what about you, Georg? Which initiatives would you like to see?
No, I would like to see some modern approaches where we take the opportunity to sort out some part of the business to online dispute resolutions, which are granted by the state, which is not some eBay story or some kind of internet provider based in China who is delivering a tool which may work perfectly, but maybe is not fitted with an algorithm European style. So I would really love if European systems would come up with solutions of getting, let's call it, easy cases, even if they are litigious, put into some kind of data stream where at the end judiciary is provided by a state authority which we all trust. And I don't mind which country it is. It's I would trust that the Dutch institution is the way, like I would trust the Austrian or the Swedish institution. It is said that you have a trusted base where you can, I don't know, put in your evidence immediately after the car traffic accident you had, maybe loading up your pictures, where you can use this link to forward it to an expert who is delivering an expertise which is public, etc., etc. So coming up with some new service which is online based and is providing a decision in a quick time would be really, really cool, and should have the exit if you're not satisfied at the end to end up in front of a human judge. Why not? Yeah, but then the costly game is maybe starting, and up to that first part it is done with, I don't know, a service fee of 100 euros or something. And I think this is more than the time to do that. And I'm looking forward if one of the European countries would go on with this, or maybe it's even something for European Commission, who is not responsible for that, for the judiciary in that way. But I think there's the time for, and this would help to sort out cases also from the systems, which are otherwise backlogged in times of lockdowns.
Thank you. I really agree. That would be really interesting. We hope for such an initiative coming really soon. So we have gone through the questions I wanted to, and I know we have some very interesting questions in the comment section. So I'm going to just quickly look through them. We have a question from a US lawyer here, from Adam. They are constantly debating in the US how much should the judge guide the case, or let the lawyers handle the case the way they want. He's very curious to hear the European or civil law perspective. Should judges take a stronger role in controlling cases?
In a system where, in the Austrian system, where the parties are deciding what are they bringing up in front of the court, and they're more or less offering their story and their ongoing procedure, I became always a little bit pushy if I realize that someone is starting to steal my time. So it is to be very attentive on, is it still to produce more content to get another hour or another hearing to invoice it on the lawyer side, or is it still focused on solving the dispute? So in the system where I'm coming from, it's a mix. The parties are kings in the way that they decide what kind of story we are talking about, but on the other hand, the judge is having a clear focus on deciding that kind of dispute. And if the judge thinks it is to be decided, then turn it off, turn the show off. I'm in favor of this because it opens both, leaving them their work. On the other hand, it is the goal to provide a decision. It's a little bit difficult to talk about the golden rule in this. The extremes are not, we wouldn't like the extreme things either. If you put it only in the hands of the parties, then you end up with some fantasy stories like Niklas said. And if you only leave it to the judge may also miss the point in the civil procedure where it is not him to decide what people bring up in front of the courts.
No, I agree. I think that we probably, as a general rule, as judges, are too restricted in guiding the parties. I don't think that we would lose their trust by addressing the fact that if they make the case this big, they're going to pay for it. And try to narrow the scope of their dispute. But of course, they are the kings of the dispute. It's a difficult question.
Yes, thank you. We have another question from Oliver with that he has a question about security issues with online hearings. Do we need to worry about attacks from people watching a hearing? For example, there could be confidential information, I guess, if we have online hearings and we want to protect certain kinds of information. What's important for the courts to think about when it comes to remote hearings, when it comes to confidentiality and so on?
First of all, if it is a protected content because it is confidential or it is about minors and you would not do it in public in the real world, you of course do not online. This is the same logic. And second question also, yes, of course you have to do it in a secure way on internet, that it should not be interfected from the outside. So we're talking about a closed system which is opening up stream content, yeah, but not some open discussion like, I don't know, here or in Zoom or whatever, where everybody more or less who has a link is joining in and is then showing pictures of his body parts, nobody's interested or whatever. This has to be avoided. But again, we are at that fact that 95% of the people behave normally. And I haven't heard stories from those countries who ad hoc switched to some online hearings with some kind of easy measures like Skype trials or something like that, or even on Zoom, that they were immediately bombed. Yeah, but the risk is there. That's true, and you have to take care. So if you set it up as some kind of solution for a long time, then you have of course to secure it and put it up in a proper manner.
Yeah, and of course the issues are there, but at least in a Swedish system, 98% of our court files are fully open for anyone who wants to see them. Everything is open. So data protection, of course, you could see the risk that someone would look into papers that are forwarded online, etc. But on the other hand, they could just go to the court and get them easy without any questions being asked. So for the majority of cases, it wouldn't be a big issue.
Thank you very much. Do we have, Adam says he thinks that Europeans are more civilized than Americans. I don't know about that. So do we have any last questions from participants? Otherwise, I think I will round this up.
I may pick up one question,
Yeah,
because this I see here in the comments. Elena asked us, or Iena asked us about anthropological speaking body language. If this is really the thing in front of the court to decide if someone is speaking the truth or not. Yes, I know this. I was even trained in this, and I know about blinkering eyes, and I don't know, being nervous. Even the experience of a judge is, of course, of that you. After 100 witnesses, you get a good feeling of if someone is telling you the truth or being too nervous to do it. But as Niklas said earlier, the sad reality is that in more than 90% of the cases, it is not that dramatic like we know it from movies and TV shows. People are simply telling their truth and doing it honestly. It is very seldom that really someone is trying to lie in front of your face and telling you a fake story. So I guess I would even realize now if Andrea is sitting in front of me like this and starting to tell some kind of strange story, even smiling like this and then telling something, I mean, I would be careful. And on the other hand, there must be always this exit. So if I would have the feeling that I'm in an online hearing and something is strange, even maybe the loaded gun I can't see, or someone is starting to tell weird stories, I would stop and would switch the hearing for next week into a physical courtroom. I think this is able to handle.
And just once again saying that, of course, the old school way of doing things has its advantages. Of course it does. But you need to weigh those advantages against the disadvantages of people having to put the whole, if they have a short testimony to give, their whole day is lost because they have to travel to the court, they have to take all the time off work, etc. Sometimes for a testimony that is 5 minutes long, and they ask 3 questions that are fairly undramatical, that ought to be able to be done in another way.
Yes, I absolutely agree. So thank you, everyone. I'm really glad we had this conversation. Thank you very much to Georg and Niklas for taking the time to participate and for your contribution in this discussion. Thank you to everyone attending, and thank you also to Malin and Linnea for technical support. We hope to be back in a few weeks with our next webinar, so please stay tuned and look out for this recording on YouTube. Thank you, everyone. Have a very nice day.